Good morning and welcome to today's webinar brought to you by the Current Consulting Group and sponsored by ClearStar. I'm Jessica Polk of the Current Consulting Group, and I'll be conducting today's presentation entitled Updating Your Drug Testing Policy for 2025. This presentation has pre-qualified for continuing education from HRCI and from SHRM for those who attend the entire live presentation. And so we'd like to invite you to stay with us the whole webinar time and qualify for those credits. Today's sponsor is ClearStar, and we're excited to be working with ClearStar on this webinar. For 3 decades, ClearStar has equipped businesses worldwide with superior background check software, services, and verification tools, ensuring a smooth onboarding journey. ClearStar has also become a leader in drug screening and occupational health services. With a customer network of over 20,000 sites and their cutting-edge ClearMD ordering system, ClearStar leads the way in all screening needs. And so with us today from ClearStar is Todd Schulberg, and also from Current Consulting Group is Bill Current. Todd is the current president of Medical Information Services for ClearStar. ClearStar is a trusted provider of background check technology, background check and drug screening services. And Todd has been with ClearStar for over 18 years and has over 25 years in the industry. He currently oversees ClearStar's Occupational Health and Drug Screening Division and the in-house MRO office. And also Bill Current is with us. If you've been on our webinars before, you're familiar with Bill, but I'll go ahead and just remind you a little bit about him. Bill is the founder and president of Current Consulting Group. He also serves on the NDASA Board of Directors and the NDASA Foundation for Trustee. He's the former VP of Consulting Employee Information Services and a former executive director of the American Council for Drug Education. He is the former director of the Institute for a Drug-Free Workplace, and he has authored 10 books on substance abuse prevention and drug testing. And with that, we'll go ahead and turn the time over to Bill and Todd for today's presentation.
Okay, thank you very much, Jessica, and welcome everyone to today's webinar presentation. I just want to pause on this slide for just 1 second to tell our audience that Todd and I have been friends and business associates for many, many years. And he's always a wealth of information. What you might not see if you don't know Todd during this presentation, what you might not actually see is he's the funniest person I've ever met in this drug testing industry. And so maybe some of that humor will come out. Todd, I'm giving you a heads up there to go ahead and be as funny as you normally are.
No pressure. Thanks, Bill.
Yeah, no pressure. I could tell stories, but I won't. Maybe at the end if we have time. Now, the agenda we're going to follow is laid out on the screen here, but we want to invite you to ask any questions that you have for myself or for Todd, anything to do with today's presentation, for the services that ClearStar provides, how they might be able to solve some of the challenges and problems that you may be experiencing with your employee screening programs. So ask any questions you want, put them in the Q&A section there online, and we will try to get to all the questions before today's webinar presentation concludes. Now, one of the things we're going to do during the presentation is we're going to insert some poll questions. So, Todd, let me turn it over to you for our first poll question.
Thanks, Bill. Yeah, as Bill said, we want you guys to ask questions to us, but we do have some questions for you all. So the first question is, do you currently have a drug-free workplace policy? Yes, of course we do. I think so. Let me dust off the cobwebs. No, we don't. Or I have no idea. I'm going to launch the poll. You'll see it on your screen. If you could please vote now. Okay, let's close down the poll and let's share the results. 81% of you on the call said, yes, of course we do, which is awesome. 9%, no, we don't. 6% thinks you might, but it's maybe a little rusty. And 4% have no idea. And this will lead right into our first section about an effective drug testing policy. Thank you for voting.
Yeah, and one of the things that we do at the current consulting group every year, and ClearStar is one of our valued partners in this, is we conduct a survey. In the first part of the year, we conduct a survey of the drug testing industry. So we talk to drug testing providers, companies like ClearStar, that can help you with your drug testing, your background screening programs, et cetera. And then the second half of the year, we ask questions of employers. It's an employer survey on their drug testing practices. And so we're going to start out with a couple of poll results or questions from our survey last year and the results. So the question that's on the slide here is, why would you establish and maintain a drug testing program? And as you can see right in the middle, that horizontal orange bar, 85% said safety in the workplace. And you'll see that throughout our surveys, that continually is identified as the #1 reason why employers conduct drug testing. Now, they may be required to do it under the Department of Transportation regulations, as you see up there. 54% said to comply with the DOT regulations, or down at the bottom a little bit more, 51% said to hire the best possible job candidates. But in the end, the #1 reason is to protect the safety of the workplace and to ensure that the well-being and the safety of workers is secured each day as best as possible. And so safety is always the #1 reason. You can see there were other ones up there. They're all good reasons, of course. We're going to talk about reasons here as we get into the policy, but keep this in mind, right? The #1 reason why you would establish a program is to protect the safety of the workplace. And when we ask the question, what benefits does your company realize from drug testing? You can see up there at the top, 87% said to improve safety in the workplace. So that was the #1 motivation for doing drug testing. It's also the #1 benefit that employers identify from their drug testing program. So there's some other good ones right there on the slide there. 63% said it enables them to hire better quality employees, and 61% said it improves their company reputation, which is important, right, when you're trying to attract good quality job applicants to your company. But the #1 reason to drug test is safety, and the #1 benefit identified by employers from their drug testing program is a safer workplace. So with that, let's launch into some policy-specific issues. So just a little bit of my background. I started out in the drug testing world working at the U.S. Chamber of Commerce back in the 1980s, and that was when drug testing was really sort of barely coming into its own. And we formed a coalition at the Chamber called the Institute for a Drug-Free Workplace, and I later became the director of the Institute. One of the benefits I got from that experience was that the corporations, the representatives from these large corporations that sat on the board of directors of the Institute for a Drug-Free Workplace were some of the brightest people in business, from corporate HR, corporate safety, et cetera. There was IBM, Hoffman LaRoche, Exxon, et cetera. There were about 15 companies on the board of directors, and we had a project where they all shared their drug testing policy. Now, this was in the late 1980s, right? So still a lot to learn in terms of how to address drugs in the workplace, drug testing programs, et cetera. But all of these companies shared their policies, and we put it all in a binder, and everybody got a copy of everybody else's policy. But it was really where I started to study policies, and in particular, the impact that state laws have on corporate or workplace drug testing programs. And I came up with this list years and years ago, and it just still applies. These are what I call the critical components of an effective policy. And let me say that when you consider the components of an effective policy, a one-size-fits-all template type policy is just an invitation for trouble, right? Because one of the things that you're going to see that we're going to talk about, you see that the last bullet there is state law addenda. That's making sure that your policy complies with all the state laws that apply to you. I get asked that question all the time. We're in 25 states, Bill. Which state law do we comply with? And the answer is all of them. So you write a general base policy, perhaps fashioned from your home state, your headquarter state, but then you add addendums to the policy for the various states in which you have business operations where your employees live and work. You start out with a purpose statement, right? So that was a little bit of what we saw in those results from the surveys, right? Why are you doing drug testing? Because why you do drug testing will influence everything else. And I'll get into detail on that. Who's covered by the policy, the kind of training and education that you're going to provide, what kind of conduct is prohibited, and then you get into the specifics of how and when you're going to conduct drug testing and the consequences for violations of the policy as you communicate it to your workers. Now, sometimes I think there's a temptation to sort of gloss over a purpose statement, but the purpose of the purpose statement is to give direction to your program. It's the blueprint for everything that you do under your drug-free workplace program. And so carefully identifying your objectives, what you hope to achieve from drug testing comes first, and then you start to draft a purpose statement. And that purpose statement will be at the top of your policy. It'll be the first thing that your employees read as they review the policy, so they understand why you as a company conduct drug testing. And then it influences everything else. You see in that last bullet, how you test, who you test, when you test, will all be affected by and influenced by your purpose statement, your objectives for your drug testing program. And then you're going to talk about who's covered by the policy. So are you going to do pre-employment testing? Will it apply to all job applicants or just applicants for safety sensitive positions? Which employees will be covered? All employees? Only employees in certain locations? Only employees in safety sensitive positions? Now, a lot of these questions will be answered by the state laws that apply to you. There are some states that will dictate, the answer to these questions to some extent. That's why these addendums to the policy for each state you're in are critical to the success of your program. But who's covered is one of the very first things that you put in your policy, so that as employees and supervisors use the policy as a guide to helping the company create and maintain a drug-free workplace, it's clear who the policy applies to and under what circumstances. And then you train. Now, there's supervisor training, and on the next slide, there's employee education. Supervisor training is important because you want to put into the policy what's expected of supervisors and also what's not expected of supervisors. So let's start with what's not expected. You don't want to ask supervisors to do things they're not qualified or trained to do, like diagnosing a medical condition. That's not what the purpose of the policy is, or the expectations that you have for your supervisors. What you want them to do is what they do best, which is keep the work flowing, keep an eye on performance, make sure your workers are being productive, that they're obeying safety rules in the workplace, etc. Those are the things that your supervisors have been trained to do, that they're good at doing. And some of those things are affected by drug-related impairment on the job. And so one of the things that is important is to provide what is often referred to as signs and symptoms training. Now, again, you're not asking them to diagnose a drug issue. You're not asking them to accuse anybody of being a drug user. But when they know what the signs and symptoms of drugs in the workplace are, they're able to identify them and, depending on your policy, refer the individual for a drug test. And that process is articulated in the policy. So the supervisor training component is very important, and as is the employee education component of your policy. Now, some states, again, will dictate what type of supervisor training or employee education you have to provide if you're going to do drug testing in that state. But one of the key things that's critical to the employee education component of your program is to make sure they understand what's in your drug testing policy, so they know what's expected of them in terms of prohibited behavior and what possible consequences could come from a drug test, and the fact that you're going to keep everything confidential. You're going to comply with the laws that apply to your company, and especially in states that have legalized marijuana to some extent, whether for medical purposes or for recreational use, you want to comply with those laws as well. You have to. right? And many states have written into their medical marijuana laws some what we call anti-discrimination language that protects the right and the privacy of what I call card-carrying medical marijuana users. But these are people who have registered with the state typically to be able to use marijuana for medical purposes. It doesn't matter whether you believe marijuana is a drug or is a drug or a medicine or not. There's lots of different opinions on that, but you want to comply with the laws that exist in the states where you do business, so that if you do test somebody for marijuana because there was reasonable suspicion that the individual was impaired on the job or under the influence on the job, your policy takes into account whatever restrictions or conditions may be applied, and your employee education program can share that information. It's not a secret, but you want your employees to know what's expected of them and what your program includes so that they can have confidence in the program. Now, let's move on to prohibited conduct. This can be a lot of different things, right? And again, can't emphasize this enough. There are many state drug testing laws or state laws that affect workplace drug testing that articulate all of these conditions, right? This is what conduct can be prohibited in the workplace. So a few of them are, and you see this especially in the legal marijuana laws, but consuming drugs, including marijuana and alcohol, while on the job. This is something that every employer has the right to prohibit. And depending on the marijuana law that applies to you, there could be specific guidance in that legal marijuana law that will help you put together the language that you're going to use in your policy and the information that you're going to use to educate your supervisors and your employees. Another thing that is universally permitted is prohibiting employees from being impaired by or under the influence of drugs while on the job. Now, you may ask, what's the difference between impairment and being under the influence? I'm not going to try to answer that question because there is a difference, but you find that from state to state, local lawmakers use those terms interchangeably. And so, while there may be a difference between the two, local lawmakers typically don't make a distinction. So you'll see both terms used even in the same law. But it's important to know that if an individual is impaired on the job, regardless of the reason, you don't want them functioning within the scope of a safety sensitive occupation. You don't want them driving a delivery van or operating heavy machinery, etc. And as an employer, you're not accusing anybody necessarily of being a drug user, but you have the right to prohibit an individual from doing certain job functions if it's believed that they're impaired. Now, an important note here that probably Todd was getting ready to bring up because he comes in on the next slide, but a drug test doesn't prove either scientifically or legally that an individual is impaired. We don't have that standard with drug testing like we have with alcohol. With alcohol, we have a national standard, right? And you see it reflected in the DOT drug and alcohol testing regulations. But for marijuana, for example, we don't have a national standard that says if you test positive at or above a certain level, you are legally impaired. We don't have that yet. So we typically say a drug test does not prove impairment, but it could prove, a positive drug test result could prove that somebody has drugs in their system at the time of the test and possibly could be impaired or possibly could be under the influence. But your concern is to make sure that individuals are fit for duty. And so being at work well impaired or under the influence or with drugs in their system is something that you can write into your policy, again, in accordance with the various laws that apply to you at state by state, on a state by state basis. But you want to make sure that you're not accusing anybody of being impaired by drugs, but you're taking action because there's suspicion of somebody being impaired, regardless of the reason. And then the last bullet there, demonstrating the signs and symptoms, and that could tie back into the suspicion of impairment, right? We're going to talk about the different specific reasons why you might conduct a drug test, but the signs and symptoms goes back to that supervisor training that we talked about. And if a supervisor observes somebody displaying the outward manifestation of being under the influence, the signs and symptoms, then certain components of your policy kick into place and the supervisor knows exactly what to do in that circumstance. So Todd, let me turn it over to you for the next part.
Thank you, Bill. The drug testing is an important component of a comprehensive drug-free workplace program and might be the one that everybody on this call is most familiar with. When we talk about drug testing, there are 5 main different types of drug testing. You can see them on the screen. We have lab-based urine drug testing, point of collection or instant urine testing, hair testing, lab-based oral fluid testing, or point of collection instant oral fluid testing. It's important to understand the differences between each of these different testing methods to know which is right for your situation. There's a whole other webinar that we've done in the past, and we may do it again later this year, that really spends the entire hour on these 5 different types of testing and goes over the pros and cons of each, because there definitely is a time and place where each of these makes the most sense. It's important in the policy that you are as comprehensive as possible on which of those testing methods that you're going to use. There are some people that do more than one. So keep in mind, there are some companies that may do urine testing for pre-employment, they might do hair testing for random, and they might do oral fluid testing for post-accident. So it's okay to mix and match, as long as it's written in the policy and you're being upfront with your employee base on which methods you're doing and why. When you talk about how, again, you're being you're giving your employees as much information as possible. You want them to know when they'll go for a collection, whether they're going to a facility, whether someone's coming on site. It's also important for them to know that if a drug test is non-negative at the laboratory, is it going to confirmation testing? Is it going to a medical review officer to go ahead and review it to look for prescription informations? I can tell for all of ClearStar's clients that are on the call right now, all of your testing that goes to the laboratory does go automatically into confirmation testing if needed, and then does automatically go through into the MRO process. So you don't need to worry or ask about that. The next part of drug and alcohol testing is when. On the screen, you see the 6 main trigger events that would typically cause a drug test: pre-employment, reasonable suspicion, post-accident, random, return to duty, and follow-up. Pre-employment is probably one that you're most familiar with. That's the one that most employers do. Person has to pass a drug test before they can start working. So kind of self-explanatory. The other ones, maybe not so much. Return to duty and follow-up. These would be used if you have a second chance policy, for example, and you have an employee that tested positive, they may have to go to some type of treatment program and then pass a return to duty test before they come back to the workplace. And then when they're back in the workplace, they may have a series of follow-up testing that they might do. Post-accident testing is what it sounds like. After an accident occurs, a person would go for a drug test. It's important that your policy also addresses what is considered an accident. If you get a paper cut, is that an accident? If you're driving a forklift in a warehouse, is that an accident? If you drop a case of copy paper on someone's foot, does that constitute an accident? Is there a monetary threshold that constitutes what an accident is? So it's important that you put this information in your policy so you know when that gets triggered to do a post-accident drug test. The last two, they get confused a lot, random and reasonable suspicion. So I kind of want to spend a minute to really have you explain the difference between the two of them. We pull randoms for many of our clients here at ClearStar. And I would say at least a couple of times a quarter, we will get a phone call from a company that says, hey, when you pull our randoms this quarter, can you please make sure Johnny's name is picked? And I'm sure some of you have had that thought before about the Johnny in your workplace. However, that's not a random testing. That's reasonable suspicion. So we have to educate the client and explain, okay, if you want Johnny to be tested, you really need to do that under reasonable suspicion, which is why a few slides back when Bill was talking about the supervisor training and the signs and symptoms becomes really important, because you're empowering that supervisor to know when that suspicion rises to that level in order to order a reasonable suspicion drug test. The worst thing you can do is not do that, have the suspicion, convince your vendor to do it under a random, or even you just do it under a random testing. Because if something happens and that person's positive and wants to fight it in court, and the policy comes into play, the test was not authorized under the policy, under the current rules, because it was not a random test. When we do random testing, it is truly, you give us a list of names, we put in a computer generating software, and then we spit out the correct number of names each month or each quarter for testing. And you know it's truly random because you will have people in the workplace that get chosen every time, or they get chosen every other month. And the people complain about it and they say it's not random. But what's funny is you never hear the other people who never get chosen, who say, I've worked here for 3 years and I've never been chosen. So it does go both ways when you talk about random testing. But it's important that you outline in your policy what are the different reasons that someone would go for a drug test, and what are the rules around when they go for the drug test. Now, when someone tests positive for the drug test, then your policy goes over the consequences. And I believe that's our next slide.
Now, some of what Todd just talked about, you may be thinking, how do I decide which of these testing circumstances I want to adopt? Well, if you fall under the DOT regulations, that's all decided for you. If not, you might be, influenced in your decisions by the state laws that apply to you. But generally speaking, all of the circumstances Todd just mentioned are available to you in virtually every state. There may be some restrictions on random testing in certain states. You have to take that into account. But the other thing that is often influenced by what's in a state law are the consequences for policy violations. So a drug testing policy or a drug-free workplace program and policy statement are really sort of worthless without some kind of consequences articulated in the policy and communicated to your employees and supervisors. And that could apply to applicants and it could apply to employees. So for example, if an applicant tests positive on a pre-employment drug test, is the offer going to be rescinded? Because typically with pre-employment testing, you're conducting the test as sort of a condition. In other words, a conditional offer has been extended pending the result of the drug test. And some state laws actually write that requirement in there. In other words, you can't do a pre-employment test until you've issued a conditional offer of employment based on, a few other things that are about to happen, like a drug test result or perhaps a background screen result. So if the individual fails the drug test, they test positive, will you rescind the offer? And is that written into your policy? Or you may rescind the offer, but they can reapply. And in some states, there'll be a minimum time in which an individual has to wait before they can reapply for employment with your company. And that's particularly true, excuse me, in states that offer certain benefits if you conduct drug testing. We call them voluntary state laws, where you voluntarily choose to participate in the program, and in exchange you get, say, like a 5% discount on your workers' compensation premiums in that state. But it will dictate certain terms as it relates to consequences. And part of that would be that an individual can reapply, but they have to wait 6 months, or not typically 12 months, but it could be as much as 12 months. But typically you'll see 6 months or 9 months written into the law. So take that into account when you're writing your policy. And if your base policy says one thing, it's okay for there to be an addendum to the policy for a state where the standard is different. In other words, California is a very restrictive state when it comes to random testing. But you don't want to base your entire policy on California law if you're headquartered here in Florida, where Todd and I live, or Texas or some other state that allows random testing without the limitations that exist in states like California. So you have an addendum for California, but you base your policy, your base policy, on the legal conditions that exist in Texas, for example, or Florida. Now, when it comes to employee consequences, that could include up to termination, right? Or it could include, as Todd mentioned, some type of second chance agreement in your policy, where the individual may be referred to a substance abuse professional known as a SAP, and there's a process that kicks into place. With DOT testing, it's mandatory if you don't terminate the employment of that individual who tested positive in violation of the DOT regulations. But outside of the DOT regulations, again, you're going to be under the auspices of the state laws that apply to you. And so, do they require you to give individuals who test positive a second chance? And if so, what are the conditions of that second chance? And who pays for the rehabilitation or the treatment or the counseling that individual is going to be required to complete successfully in order to return to work or to return to a safety sensitive function within the company? Those types of details go into your policy so everybody understands, but they're often governed by the laws that apply to you. Excuse me. And that brings me back to something I've already referred to numerous times, which is the state law addenda. So this is where your policy becomes customized to your particular circumstances in terms of what consequences you want to be in play, what type of behavior will be prohibited, when you'll test, how you'll test, who you'll test, etc. But all of those things are typically affected by the state laws that apply to you. Now, I mentioned earlier, people ask which state law do we comply with if we're in multiple states. My answer is always all of them. But you may not need 25 different policies. You may need just one base policy with X number of addendums to that policy. Say, for example, you want to do random testing and you're based in Texas, which allows employers to conduct random testing. Very, very few restrictions on drug testing in the state of Texas. But you have business operations and employees who live and work in California where there are restrictions on random testing. There are restrictions on other types of pre-employment testing as well. So those things get written into an addendum just for California that only applies to your workplace in California. So the policy remains in effect, but when you get to the random testing section of your base policy, which aligns with Texas, there will be a note in your policy that says refer to addendum, whatever the number is, for information about random testing in California, for example. So that your policy is customized not only to the specific objectives that you have, but also the state laws that apply to you. If you don't include state law information in your policy and you're a multi-state employer, then you're really asking for trouble, right? Because you may do random testing based on the situation in Texas and try to apply it in California, and then because your policy didn't address that issue, you're really inviting trouble. So we want to stay out of any kind of trouble, right? We don't want to be accused of being out of compliance with state laws that apply to you. So you want the addendums to the policy for the various state law conditions that differ from what you've written into your base policy. And these are all things that we can help you with, but it's very important to note that, okay? I've spent a lot of time on state laws, but let me explain the different kinds of state laws, because these all come into play when you're putting your policy together or when you're reviewing your policy. It's critical that you review your policy on a regular basis. Last year in 2024, one of the things we do at Kern Consulting Group is we monitor state legislation that can affect drug-free workplace programs, whether it's drug testing or background checks, etc. And last year, there were almost 600 bills introduced at the state level that, if passed and enacted, would have had an impact on workplace drug testing. Now, not a lot of those bills ever get passed, but some do. Last year, Minnesota, for example, altered its laboratory licensing law, which has governed how drug testing is performed in the state of Minnesota, to now allow companies to use rapid result or point of collection oral fluid testing. That's an interesting development, right? Because it's a laboratory licensing law that's allowing point of collection testing. That's a different topic for a different webinar, but the idea is that these things happen. There are states that amend their marijuana laws to place other conditions on employers that you need to be aware of, and you update your policy to reflect those changes. Now, there are basically two kinds of drug testing laws at the state level. There's mandatory laws and there's voluntary laws. And I know voluntary seems like an oxymoron, right? If it's a law, don't we have to comply with it? Well, if it's a mandatory law like exists in Iowa, then it applies to every employer that conducts drug testing. But here in Florida, we have a voluntary law. It offers a 5% discount on your workers' compensation premiums, but it's voluntary in terms of whether or not you as an employer choose to register your company in that program. If you do, then there are specific drug testing conditions that apply if you're going to qualify for that 5% discount. And there are other states like that. Georgia, for example, Tennessee. Those are states, just a few examples of states that have voluntary laws that offer a 5% discount on workers' compensation premiums. There are other states like Utah. Utah has a voluntary law, but it doesn't offer a workers' comp discount. At least it didn't in the past. I don't think it still does. But it does offer employers limited protection from liability when acting in good faith upon the result of a drug test. That's interesting. That's an interesting development. Similar law exists in Alaska, where it's not based on a workers' comp incentive to do drug testing, but on legal protection from lawsuits if you act in good faith upon the result of a drug test. But it will dictate how you conduct drug testing, when you conduct drug testing, who's subject to drug testing. So you need to be aware of those things. But that's the difference between a mandatory law and a voluntary law. Now, there are some states that have industry-specific laws. Illinois, for example, has a law that applies to public works contractors with the state. So if you have a contract to do road repairs somewhere in the state of Illinois, you're required to comply with that specific industry law. That only applies to companies that have contracts with the state in public works. There are states that have mining industry laws. There are states that have laws that apply to certain types of transportation workers who are outside of the DOT regulations. So it's important that you know what those laws are if you're in those particular industries. Now, in addition to workers' comp and unemployment comp issues that, especially workers' comp with the workers' comp discounts that exist in states like Florida, for example, many states, most states have language written into their unemployment comp law and their workers' comp law, I should call them regulations really, that allow employers to move to deny paying benefits to an individual who tested positive in a post-accident drug test or whose employment was terminated because of a positive drug test result. Now, it's easy to say that, but again, you got to delve into those state regulations to know specifically what type of drug testing they allow and under what circumstances. So most states are pretty employer friendly when it comes to these denial laws, but you go in there and you read it to make sure that if that's important to you, if you're in a safety sensitive industry, for example, you have a lot of workers' comp claims because there's a lot of accidents in the workplace that result in workers' comp claims. If you've got a positive drug test result in some states, that's evidence that the individual was impaired. Again, like I said earlier, the drug test result doesn't prove somebody's impaired, either legally or scientifically, but some states have language in their workers' comp regulations that refers to a positive drug test result as evidence or proof of impairment. It's not technically, but under that specific regulation, a positive drug test result is your best friend because it may put you in a position where you can deny benefits to somebody who tested positive following an accident. Now, of course, we've already talked about these, and like Todd said, this could be an entire webinar all by itself, medical and recreational cannabis laws. The important thing to keep in mind here is that no two state marijuana laws are identical. They're all different. And what happens often is that a state will pass a law either by referendum of the voters or by legislation in the state Senate, for example, and it'll do one thing. It will legalize the use of marijuana for recreational purposes, and there'll be some conditions on that. Or it will make medical marijuana use legal, and there'll be conditions on that. But then what typically happens, and I mentioned those nearly 600 bills that we were tracking last year, what typically happens is that then after those laws get passed, then the pro-legalization folks, bless their hearts, they go back in and they get more things added to the law that then have to do with typically, among other things, the workplace. And so a law may get passed and have no reference to the workplace, even though it's going to have an effect on your drug testing program and your policy, but later these things get added in. So always not only be aware of what the law is, but be aware of the changes that are occurring in the laws that apply to you. But my advice is if you're in a legal marijuana state, and most states do allow medical marijuana for sure, is make sure you're in compliance with those laws because they will work against you if you think that you can sort of flaunt the law and do whatever you want. You can't. You can't discriminate against medical marijuana users depending on the conditions that apply in the state that we're talking about. And you want to make sure your policy reflects that. Now, one other thing, case law. There are states like California, which doesn't really have a mandatory drug testing law, but has a lot of case law. In other words, lawsuits over the years that have been decided and have essentially formed the infrastructure of a drug testing law. And so I mentioned random testing in California. California is the best example of all of this because there have been so many lawsuits over the years in California. Some have gone in favor of employers, some have gone in favor of the individual, the plaintiff, but in many cases, those laws sort of shape how drug testing is done. So be aware not only of the statutes, but of the case law decisions that may influence how the statutes are carried out. And then one last area is federal regulations. So the DOT regulations, for example, trump state laws in the same way that state laws trump city ordinances. So at the federal level, under the DOT regulations, you're required to drug test, you're required to test for marijuana, for example, and you're allowed to do it with urine. In fact, you're required to do it with urine at this stage. Soon we'll see oral fluid, lab-based oral fluid regulations that employers can use to use oral fluid. It's already been passed by DOT, but we're still waiting for certain conditions to be met. But I mentioned that as an example because in California, in January 2024, a new law went into effect that prohibits employers from taking action on a positive test for marijuana if that test method was only revealed the presence of metabolites of cannabis as opposed to the actual parent drug, THC itself. So in California, you can't use urine testing if you're going to try to take action based on a marijuana positive. You can use oral fluid because that's a test result that shows the presence of the parent drug itself. But in California, urine testing for marijuana only is restricted. You can use urine testing for other drugs, just not for California. In Washington, it applies to pre-employment testing. Same restriction. In California, it's pre-employment and employment testing, post-hire testing, except in the construction industry. That was exempted from the law. And in Washington for pre-employment, there's a long list of exemptions. And again, it doesn't apply to post-hire testing. So you can do random testing, for example, in the state of Washington for marijuana with urine. But if you're under the DOT regulations, you must comply with the DOT drug testing requirements, even if your state law differs from the DOT requirements. In other words, the DOT regulations trump whatever restrictions may exist in your state law. Now, you're going to have a different policy just for your DOT program than your non-DOT workers. One of the things that the feds hate is when they come in to do an audit and you got your DOT and your non-DOT programs all bundled together in one policy and they can't figure out which is which or what is what. So typically you're going to have a DOT policy, standalone DOT policy, and then you're going to have a non-DOT policy as well. Now, how these laws work together is sometimes very complicated, right? Especially if you're a multi-state employer. So just make sure that as you put your program together or as you review it and you're looking at updating it, that you've taken into account all the different laws that apply to you depending on the states that you're located in and the federal regulations that may apply to you, like under the DOT regulations. Look at that. Let's see, fourth bullet down, drug-free workplace policies need to ensure compliance with specific state laws, and multi-state employers should have custom addendums for each state. We talked about that. I've mentioned it several times, but a template, a blanket template or model policy is typically going to be insufficient for your needs. Now, we're going to launch into the 5 most common mistakes employers make in regards to their policy, but as we do that, let's do another poll, Todd.
Thank you, Bill. Yeah, we have about 15 minutes left and we have a few more polls coming up, so you want to stay near your computer for these next few slides. When was the last time you updated your drug-free workplace policy? And please vote now. Okay, we'll close the poll and let's see how the results came out. 26% within the last 12 months, 26% within the last 12 to 24 months. So that's, over half the people in the last 2 years, which is awesome. Then we have 15% over 3 years ago, 9% never, and about a quarter, not quite sure when the last time it was updated.
That's a little bit disconcerting, Todd, that 9% have never updated their policy.
Well, let's hope they were policies that maybe they just started in the last year. That's why.
Okay, we'll give them the benefit of the doubt. Now, this next section on the first 5 most common mistakes really relate to things that we've already talked about. So I'll just mention them as we go through so that we leave time for Q&A. Todd will be pulling that together, but not updating your policy on a regular basis. That's problem number one, and making sure that the state laws that apply to you are reflected in the policy, especially if you expand into a new state or a new region of the country. You want to make sure it reflects the laws that are that apply to you in those new states, and also making sure that your various addendums to the policy take into account all the different types of laws. And if you're covered under the DOT regulations, keep an eye out for changes. Sometimes there are very small changes made at the agency level, say the Federal Motor Carrier Safety Administration. Sometimes they're made more universally in Part 40, 49 CFR Part 40, which are the regulations that govern how drug testing is conducted. But make sure that you refer to these things so that you're up to date and your policy is up to date. And that brings us to another poll question.
Yes, let's look at how many different states do you currently operate in? Okay, let's close the poll and look at the results. A quarter of the people only operate in one state. 29%, 6 to 15 states. 27%, over half the states. And you can see 2 to 5, 15%. So an interesting mix across the board.
And Todd, what was the percentage for 26 or more states?
27%.
Wow, that's a lot. So interesting. So a lot of what we've talked about today applies to you if you fall into these multi-state categories. And you're going to have access to the recording, so you'll be able to go through these next few slides in more detail. But a big mistake is not training your supervisors, not communicating your policy properly to your employees. And that just, you want the support of your employees when you put your policy out there or when you update your policy. So you want to make sure that they're aware of the key components of your policy. And that brings us to another poll question.
Okay, on this one, are you still testing for marijuana? And the results, 67%. Yes, we still test for marijuana. 15%, no, we dropped it. 11%, we don't currently drug test at all. And 7%, yes, we do, but we're thinking about dropping it.
Okay, 11% said that they don't test at all. So you're on this call maybe thinking you're going to implement a program. So policy is a great place to start with that. But I would also say that you should keep testing for marijuana. It's the #1 drug of abuse after alcohol. It has the greatest impact on marijuana, positive post-accident drug test results. You can see that in some of the studies that come out every year from various laboratories, where we're seeing increases in positivity for marijuana in post-accident tests. So keep testing. The legal marijuana laws do not mean that you can't test for marijuana. It just means that you have to comply with those laws while testing for marijuana. So that's my advice under the circumstances, and there's lots of different reasons for that. And we're really towards the end of our presentation, but we have another poll question for you.
Yeah, thanks, Bill. Yeah, this last one is kind of for our information. It's asking if you would like ClearStar to reach out with more information about drug screening and/or policy help. And after this poll question, we'll get into the questions that have been coming in all session. So if you'll just take a few seconds and please answer this one for us. Okay. And again, the questions are coming in, so I appreciate the questions coming in. We have almost 10 minutes to get through them. Let me close this poll. Okay, thank you again for voting in all of our polls and staying active. Okay, first question came in. Any recommendations for addressing marijuana? We are in Virginia, where it's legal for recreational and medicinal, but currently if someone has a prescription on file with the state, the test is still marked as positive with a marijuana card, and the job offer is rescinded because of the positive test, basically denying employment to folks who have a verified prescription for the substance that they were positive for. How do we address that?
Well, one, I'm impressed by how much the person who submitted that question knows about the law. That's great that you're up to date on that. I would say there are 3 things that you should do no matter what your marijuana law says in your state. 1, prohibit employees from coming to work with marijuana in their system. 2, prohibit them from using marijuana while on the job. And 3, prohibit them from being under the influence on the job, from sharing marijuana with other people at work, because then they go out during their lunch break and maybe are using marijuana. But you want to make sure that you have those things written into your policy, because every state allows that. None of the pro-marijuana states like Illinois, Colorado, California that have the most sort of liberal marijuana laws prohibit employers from doing those 3 things. And write that into your policy, communicate it to your employees, and make sure they understand that while you are going to comply with the laws that apply to you, you will not tolerate these things. So without getting into more specifics about the state you're talking about, that would be my advice.
Okay, thank you, Bill. Next one. In Illinois, can we have a drug testing policy for specific employees? For example, these work in a production department or a warehouse, but not have it for all the employees?
Yeah, so in Illinois, there's not a mandatory drug testing law like the one I referred to in Iowa. So that doesn't mean there aren't restrictions that apply in Illinois, because Illinois is one of the sort of more restrictive states when it comes to drug testing. So to answer that question, we need to know some more specifics like your industry, what your employees do. But typically speaking, this is a very general response. Workers in safety sensitive positions typically can be subjected to more rigorous drug testing than office workers or people who don't perform safety sensitive functions. And so that's one very loose way to respond to your question. But again, we'd have to get into more specifics, and I wouldn't want to have it perceived that I'm giving some kind of legal advice, because 1, I'm not a lawyer and I'm not trying to do that. But I will say that Illinois doesn't have a mandatory drug testing law. So a lot of it is determined by case law and also by the state marijuana law, which has workplace language in it.
Thank you, Bill. Our MRO uses the federal DOT guidelines and rules to verify all drug results, even if it's at our non-DOT or forensic account. Is that good or bad?
Todd, I didn't really understand that question.
The question is if a company is using DOT regulations and following those rules, but it's non-DOT testing, is it safe to cover it under the DOT rules? And even from the MRO point of view, should the MRO be using the DOT guidelines of a DOT drug test if they're evaluating levels and so forth on a non-DOT drug test?
Well, your audience, Todd, is going to start to think, why doesn't Bill ever give a straight answer to these questions? But there's a lot of loosey-goosey in that question. I will say this, though, that a lot of companies like to create DOT lookalike policies, right? In other words, they're not mandated under DOT to do drug testing, but they follow those guidelines as sort of the blueprint for their program. And that's a good thing to do. I mean, because there's some legal defensibility in being able to say, we're not required to, but we follow the very strict, rigorous guidelines issued by the federal government when it comes to drug testing. And that can apply to the MRO part of it. But here's the caution. Outside of the DOT regulations, and that's how we're talking about DOT here, the state laws that apply to you have to be observed in your policy. And there are many states that have specific language regarding the role of the MRO. So the answer to that question is it would depend on the state. And I don't want to appear to be giving legal advice, but I would say if it's a non-DOT program that's sort of based on those DOT regulations and your MRO typically follows the DOT, MRO guidelines, I would still take into account or make sure that you've taken into account any state law requirements that may apply to you in various states.
Okay, thank you. What is your recommendation for remote employees? Are you testing them, and do the rules apply to the state where the employee lives, or is it where the company is?
No, it's where the employees work. So let's say, for example, and then this gets a little complicated, okay? I'll admit that. But you can't base how you test your employees in California who work and live in California. You can't test them based on the more employer-friendly law or legal conditions that exist in Texas or Florida. I use those as two examples because those are two very drug testing friendly states. So you have to be careful that you apply the law in the state where the individuals live and work. Now, let's say, for example, Todd lives in Florida, very drug testing friendly here, but he travels all the time, and Todd does travel all the time. Does the state law where he's working that day apply to him? No, he's still governed under Florida because this is where he lives and works most of the time. He just travels like, many people do in their workplace. But if an individual works in a state, primarily in that state, then that state law applies to him. That's why you have to have addendums to your policy to take into account all the different applicable state laws.
Hey, thank you, Bill. That concludes the Q&A, and we're right at the top of the hour. I'll turn it back over to Jessica.
Wonderful. Thank you all so much for your expertise. Bill and Todd, thank you very much for going through those questions with us and for all the polls and the content-rich presentation. We hope that you who have attended today have enjoyed our webinar presentation. We hope that this has been educational and informative for you. As mentioned at the beginning of the webinar, this presentation is being recorded, and we will send you a link to the recording so that you can review this information again and that you can share it with your colleagues. We also have qualified for continuing education credits for those who have been with us for the whole 60-minute webinar. And so if you qualify for that, we're going to send you over the CEU information, those unique IDs for those credits from HRCI and from SHRM. And if you have any questions that were not answered in today's presentation, feel free to send them to Current Consulting Group or to ClearStar, and we will be happy to reach out to you. If you submitted a question that was not answered, I think they did a good job of getting through all those questions. But if there ends up that there was one that we didn't get to, don't worry, we will respond to you offline for those answers. And with that, this concludes today's webinar, and we hope you all have a wonderful day.